5, 4, 3, 2, 1. The intervener has also filed an application for permission to appeal against the judgment, and we had granted that permission by allowing that application. Though in the submission part of the appeal, it is mentioned that the association is aggrieved by the judgment in WPC number 6223 of 2003 and other analogous cases, the appeal can be understood as only against the judgment in PWC number 6220 of 2002. The result is that, strictly speaking, there is no challenge to the decision in WPC number 6545 of 2002 before us. In this context, learned counsel for the contesting respondents in the appeals raised a contention that the hearing of the appeal is barred by res judicata in view of the fact that the decision in WPC number 6545 of 2002 has become final and this court cannot render a judgment inconsistent with the judgment which has become final. He submitted that the court is precluded from rendering inconsistent judgments in the same matter, and that would be the result if the appeal by the state and the intervention were to be allowed and the resolution dated 10/10/2002 upheld as canvassed for in this appeal. It was contended by the learned Advocate General on behalf of the state and counsel for the intervener that the appeal is against a common judgment, and considering the nature of the question, it was not necessary to file a separate appeal, and it would unjust to apply the rule of res judicata to preclude the consideration of the contention of the state and the intervener on merits. Learned Advocate General submitted that the state can even now file appeals against the other two judgments along with application for condoning the delay, but that would delay the hearing of the appeal. The question related to admission to professional colleges and a quick decision was imperative, since otherwise admissions could not be completed and the sufferers would be the candidates belonging to other backward categories, including the extremely backward categories who were before the court espousing their own cause. This is really a dispute regarding the arrangement to be made relating to admissions in colleges pending final decision in the writ petitions, pending before the full bench, awaiting the decision of the Supreme Court. As clarified by the learned single judge himself, this arrangement is to endure only till a final decision is taken by the full bench. Though there is merit in the contention raised on behalf of the contesting respondents based on the plea of finality of the order in view of the writ petitions, we are of the view that in the circumstances of the case and the nature of the problem that has surfaced, it may not be appropriate to throw out these appeals on the ground that their hearing is barred by res judicata. After all, even today, the state could file an appeal against the decision in WPC number 6545 of 2002, of course, with a petition for condoning the delay in filing the appeal. We have also the discretion to treat the appeals filed by the intervener as an appeal against all the three orders. The question involved is of such a nature and is of such immediate moment that we feel that it is better to put an end to that controversy on merits rather than declining to consider the appeal of the state on merits now or postpone the hearing of the appeals awaiting formal filing of appeals by the state. We are therefore not inclined to accept the argument on the sustainability of the appeals raised by the learned counsel for the contesting respondents. The learned Advocate General pointed out that the earlier resolution that was the subject matter of challenge before the full bench was the one based on the policy of the undivided state of Bihar, taking note of the conditions as obtaining in that state as a whole. That order or the resolution had therefore provided for separate reservations to the extremely backward categories and the backward categories. But afterwards, the state of Jharkhand, in the light of the interim interdict by the full bench, had come to the conclusion that it was not necessary to provide for separate reservations to the extremely backward categories and the backward categories, and that the reservation for backward categories can be kept common, and that reservation could take in both the categories. He emphasized that it was for the state to decide what was necessary in that regard. Even though a subcategorization of a particular category may not be interfered with by the court cannot direct that the state should make a subcategorization of a reserved category. That was really a matter of policy. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.